Good morning, sir. Are you Alvin Wade?
Yes, ma'am.
And Mr. Wade, in cause number 25 DCCR 1648, you're charged with a third-degree felony offense of possession of a prohibited substance in a correctional facility from July 6th of 2024. Your indictment alleges that you were previously convicted of aggravated sexual assault on a child, a first-degree felony, January 22nd of 1998, and after that was final, you were convicted of failure to register as a sex offender, a third-degree felony, November 26th of 2018. What that means is that if you go to trial and you're found guilty in this case, and if those prior convictions are true, the range of punishment would be that of a habitual offender, which is a minimum of 25 years in prison, up to 99 years or life. Do you understand the possible range of punishment if you're found guilty at trial?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that has your signature with Mr. Rojas's and shows that the district attorney's office has made an offer, if he would like to enter a plea of guilty, for a 15-year term in prison. So that would be to go on counts 1 and 2 only. You have every right to reject that, have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. Do you understand all of that?
What counts 1 and 2?
So counts 1 and 2, that just makes it a second-degree felony instead of the habitual. So it's the offense you're charged with and one of your priors instead of both of your priors.
Oh.
So that's how we get to 15 instead of that minimum of 25.
Oh.
Make sense? And so do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get your case set for trial, Mr. Wade.
And, excuse me, can I say?
Uh-huh.
I want to invoke my Sixth Amendment constitutional right.
To,
Speedy trial,
you're lucky because in this court, we only have 50 cases waiting on trial. So every case is getting a speedy trial now. So you will get set for trial as quickly as possible and we'll get your case taken care of within a very short amount of time. Now, I wanted to ask you, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release Mr. Rojas. I can appoint another attorney who could begin preparation for trial probably a little quicker. Is that okay with you?
will I have the same right to gather the evidence?
Yeah, of course. Your attorney will get all of the discovery. They'll go over all of that with you, and then we'll get your case set for trial.
And like pictures, I need him to take some pictures.
Just listen. Let's start with, do you want a different attorney so they can prepare quicker, or do you want to keep Mr. Rojas?
If you're gonna,
Any attorney.
he told me he was a cop outlaw.
I can't imagine that Mr. Rojas used those words.
I say she'll give you a lawyer tomorrow. It's just somebody that does, they can get ready faster than we do.
You say you're a cop outlaw that legal to the DA. I need a lawyer that's gonna help me.
Any of the attorneys who I can appoint in my court are going to represent you to the best of their ability.
Your Honor, if I may, Mr. Rojas has negotiated with me back and forth on this case. We discussed this case at length, both the strengths and the weaknesses in the state's case, just for the record.
I have no doubt that Mr. Rojas has done an excellent job already. But Mr. Wade, I just need to know if I have your permission to release Mr. Rojas and appoint someone else, or do you want to keep Mr. Rojas? Is that something?
I'm gonna take your advice.
It's not advice. Don't be putting words in all of our mouths. I'm not giving you advice.
He was a good lawyer, huh?
I'm saying everyone on this list is a good lawyer. So you can keep Mr. Rojas, or you can get someone else off of the rotation who could probably start your preparing for your trial a little quicker. Mr. Rojas just handles a lot of cases for me.
Okay. Then I need a lawyer that, when I handle my case is
Quicker, because you're asking for a speedy trial and all. Perfect. So I'm going to release Mr. Rojas. I will appoint someone today. They should be out to see you very soon to begin preparation for trial. You can go back with the bailiff. You are Kaisha White. Answer out loud, please. I'm sorry?
Yes.
This is 24 DCCR 2063. And Help me out. What are we,
Judge, we pled her back in January of last year.
it was a bond forfeiture.
And there's a bond for the punishment hearing. Judge, in speaking with her in the back, she doesn't remember everything that happened last year. I would request a reset to get her evaluated.
Okay.
I don't know, I don't think she agrees with that, but I think that may be the best way to go before we
Well,
proceed.
I'll, obviously, you're the one that's speaking with her, and if there's any issue, then we want to make sure that there is everything taken care of before we go forward with any sentencing or withdrawal of plea or anything like that. And so we'll do the order today. Ms. White, there'll be someone to visit with you very shortly, a doctor, to make sure that everything is okay with your understanding of the proceedings that are going on, and then we'll move forward with your case after that. So you can go back with the bailiff. All right, again, you're Wayne Cummings, right? And Mr. Smith, what did you find out about that Orange County case?
Spoke with staff at the district attorney's office. They have not.
Can y'all stop? If you're talking about a case, keep it down. If you're not, please stop.
They have not received the case. Found out the agency, it's Orange Police Department, that made the arrest. He said, the person I spoke to said that it normally takes about 6 months to get this in. It's going to be a misdemeanor, it looks like, based on looking at criminal history and his PSI, and they thought that as well.
Okay. So then, that's really the main issue, obviously, in this motion, out past curfew and that
was the thing that
offense.
concerned me, was the time of day.
Sure, so here's what I'm gonna do. I'm going to grant the motion to set a bond. I don't want Mr. Cummings driving at all, right? So that's gonna be a condition of this bond. You're not allowed to drive a vehicle ever while you're on this bond. No one's vehicle, not yours, not anyone else. For any reason, you're not allowed to drive. Do you understand? I'm going to set the bond in your case at $25,000. Again, condition of that bond is no driving. Also, a condition of that bond is going to be that you are required to wear a GPS monitoring device at all times and remain. Do you live in Orange or do you live in Beaumont or Port Arthur? Where do you live?
I was in housing out there in Orange.
When you go home, if you make a bond, where's home? Where are you going to be? In
Maybe,
Orange?
Maybe. I'm trying to figure out. I don't know where I'm gonna go.
Okay.
I can get back with you on that.
So what I'm going to do is require a GPS monitoring device and that you remain in either Orange or Jefferson County. You need to let your bondsman know they're going to require an address so that I know where that GPS is you're supposed to be. And obviously you're still on probation. The same curfew applies. You're not to be out of your house past 10 o'clock at night. And also going to require I think it's probably because I'm requiring the GPS, a little more cost effective to do the handheld breathalyzer. So you're going to be required to have the handheld breathalyzer. You are not to drink alcohol ever. If you test positive, if you miss blowing throughout the day, it's a thing where you have to blow randomly throughout the day. It's going to tell you when. Probation and your bondsman can go over that with you also. But if you test positive for alcohol, your bond's going to go right back up and you'll be back in jail. Do you understand?
Yes.
If you need some help, you're still on probation. Go to your probation officer. Say, look, I relapsed. I was drinking. What can I do while you're out on this bond if you make it? Okay? Anything else?
You have to report to probation.
Anything else?
Go ahead.
Anything else, Mr. Smith, that you can think of?
You have to report to probation.
Okay, you can go back with the bailiff. Good morning. Are you Mon'nique Win?
Yes.
And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Wynn, in cause number 24, DCCR 1298, you're charged with the state jail felony offense of theft of property from April 8th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And so is the agreement, it looks like, for a 12-month term in the state jail prison?
Yes, Your Honor.
Yes,
She
Judge.
has 11 months
Okay.
of back time.
Okay,
So she would have to serve 1 more month.
okay.
The defense is requested if she could turn herself in on Friday. She has 3 children that she needs to get situated.
Well, so what we need to do is, I'll go through with the plea, but not sentence her, because if I sentence her, it just turns into an issue if she doesn't.
Okay.
But motions for new trial and things like that, there's really not a lot of things we can do. So, I can take the plea today. We can do the sentencing Friday. We can do the sentencing Monday during the next docket.
Okay.
I'm willing to do the week, whatever.
Couple things, Judge. If we can maybe put on the record how we arrived at that time. And also there's the state, well, ordinarily I wouldn't be opposed to a defendant turning herself in at a later date. This plea was contemplated prior to today. In other words, this defendant knew that there was a very good chance that she would be going the other day. On its face, it just looks like a plain Jane state jail felony theft. But Judge, it appears that she may have been a part of a theft ring that committed more than 29 total different crimes to the tune of about $50,000, Judge. So with all that being said, I'm not so amenable to her turning herself in later, but of course it's up to the court.
So here's what we'll do. We'll go through with the plea, and then we'll be here and do sentencing this Friday at 9 a.m.
Yes, ma'am.
Can you do that?
I have municipal court in the morning, but
What time?
they typically start at 8:30. But I could,
I mean, it won't take long.
yeah, I could tell them I'll need to leave and come and go back.
I mean, we can do this at 8:30, and then you can just, instead of starting and stopping, and just be, I mean, it'll
Little
take
late,
10
yeah.
minutes.
Okay.
Would you rather that?
Yeah, that's
Instead of starting and stopping, just let them know you'll be a little bit late?
Yes, that's fine.
Okay, so that's what we'll do then. All right, so, and you guys have talked to the clerk about the credit.
Yes, so there were several counties in which Ms. Wynn was transferred throughout from 2024 to 2025.
For various thefts.
Okay.
Yes, from various deaths in various counties. So we have we know that Jefferson County put the hold on her in June of 2024,
Okay,
and then she was released in May of 2025
okay,
after completing all the other counties.
okay,
Yes, ma'am.
gotcha. All right, so is that your understanding of the agreement?
Yes, ma'am.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Wynn is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing to this Friday, which is January the 9th, thank you, at 8:30 a.m. It's very important that you're here on time because Ms. Holmes has something else she needs to do in another court. And so we'll all be here early. We'll get your case taken care of. You'll go into custody. If you don't show up this Friday, well, just let me go. Good, I hope so. But let me just, if you don't, then I don't have to accept this plea agreement and things could be worse. You understand? Also, if you're arrested for anything this week between now and when you come back Friday, you run the risk of me not accepting that agreement. You understand? And it sounds like there's the hold, there's some documentation of the hold that we had. And so the credit from that June date in 2024 to the release date in May will be granted as far as back time.
Yes, ma'am.
Did I already? Did we already admit one?
No, Judge.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Wynn is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, again, I'm going to reset your case until Friday at 8:30. We do not need a pre-sentence report. You'll come in and be ready to go that day with the bailiff, okay? All right, we'll see you Friday morning.
All right, quick wrap up. Alvin Wade is warned this isn't a small gambliff. The priors stick. Trial could mean a brutal punishment range. He rejects the 15-year offer, demands a speedy trial, and the judge even swaps out Mr. Rojas to appoint a new attorney who can prep faster, so this case is moving fast. Kaisha White's case pauses because competency is in question, and the court orders an evaluation before anything like sentencing happens. Wayne Cummings gets a $25,000 bond, but with strict conditions. No driving ever. GPS monitoring, county limits, a 10 p.m. curfew, and a breathalyzer 1 relapse, and he's back in jail. And Mon'nique Win pleads guilty, but the judge makes it clear. Show up for sentencing, stay out of trouble, or the deal can disappear. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more courtroom breakdowns.